all things FERPA, buff style. FERPA, by definition and use, is the Family Educational Rights and Privacy Act. FERPA protects educational records, and it also protects the privacy and confidentiality of students. It is a federal law, and parents are granted the rights of their students while they're in school. And of course, these rights are then transferred back to the student upon the age of 18, when that student either graduates from high school or turns 18 while still in high school. FERPA is maintained and administered through the FPCO, the Family Policy Compliance Office, and this is contained within the Department of Education. FERPA applies to all schools who receive any type of federal money for any of the programs that are administered through the Department of Education. FERPA gives parents and students the right to prevent disclosure of private information through the educational records. And in these educational records, there's almost always personally identifiable data and information about students and their families, next of kin and friends. And so FERPA gives parents and students the right to prevent that disclosure of private information. FERPA gives parents and students the right to access their records with the ability to view the records and inspect them, and to make a request for any corrections that might need to be made within the student's record itself. FERPA protects information that's in the educational records. It also protects the release of any of that information through those records without any type of prior written consent from parents or students. Some examples of these records that are protected by FERPA would be student grades, the immunization and health records that are retained at the school for the informational purposes of each student, any type of record of discipline, any school progress reports, any physical and or academic tests and their results that have been taken by the students, the grade point average of the student, and any type of attendance records of these students. Now, if we look at any change in confusion, we'll see that with all the changes that have occurred with data and privacy laws over the years, there needs to be a new modern knowledge of these changing regulations. And through a lot of other regulatory changes, FERPA has been weakened at some points. So there are several states that have passed their own laws so that they can help better regulate privacy data. Consequently, it kind of muddied the waters a little bit and made regulations confusing overall for everybody involved. For third-party contracts, schools and districts have to be really careful when they sign contracts with any type of third parties, including vendors and others. The risk of violating information privacy is much higher when there are other people involved, and we can't always regulate everyone at all times. So schools and school leaders have to be really careful about those third-party contracts. There's a lot of confusion with the Department of Education, and the Department of Education has recognized this and is attempting to clear up some of the confusion. So exceptions to FERPA are made on the basis of situations such as disease outbreak, school shootings, and of course, any and all other emergency situations that would warrant the ability to legally share student information with law enforcement or other designated persons, and that would be within these directed situations. Now, the Department of Education has put out a brand new document, and it is intentionally been made to help people understand and clarify all of the requirements of FERPA, the information types that are protected by FERPA, and any type of exceptions to FERPA mandates that need to be known by everyone. It is a frequently asked questions document, and the new document also addresses any type of new developments that might occur within the new modern ventures of today's technological society, because there are a lot of advances within technology itself. It was made very clear by the Department of Education that schools and districts have the flexibility that they need in order to share any type of student records or information when the emergency situations call for the sharing of that information. And most of that information would be health data, safety protection data, etc. FERPA is an area where widespread confusion still remains, and it will kind of be that way on and off because of the legalities of information and its data. And this clarification of this document will give local school leaders and law enforcement better tools that they need in order to protect student privacy, while also making sure that the safety and the health of these students and others in the community are protected as well. Within compliance, digital record keeping has made privacy of information and all the aspects of FERPA a more daunting task. And it is more daunting now than it's ever been because of technological advances. Some of these tasks are even outsourced by some districts, but it's not recommended that that happen. Not only do the schools and districts house all of this sensitive and private information, but then students also have the opportunity to access their own private information and other sensitive materials via the internet and technology on a very daily basis. With law enforcement officers and the officers that are within the building for the schools to have, or SROs, school resource officers, there is sometimes questions about what their duties would be in regard to student information and student data. Even SROs who work as police officers and they double as SROs within a school building, they are not to report any undocumented students to anyone. However, the officer has to not be in a state of agreement with the director of ICE. And the director of ICE has made agreements with several states for SROs or those that are SROs that are also police officers. And those duties are different. In accordance with Illegal Immigration Reform and Immigrant Responsibility Act, together with the Immigration and Nationality Act, the director of ICE has the authorization to go into agreement with any local or state authorities and law enforcement in order to permit certain designated officers to perform duties that would be those that function as immigration law enforcement. And these designated officers are required to go into, of course, specific training and education through ICE, and they have to do that first and foremost. Besides those that are in agreement with the directors of ICE, other SROs and law enforcement who are simply police officers in the building or who frequent the building, they are not to report any undocumented or illegal immigrants. When we're talking about FERPA compliance, there are 8 ways to make sure that FERPA compliance is adhered to in school buildings. Number 1, of course, raise awareness about FERPA. Always making sure that all the employees are aware of FERPA. They know what FERPA is, what the consequences are for not complying with FERPA, and to be really knowledgeable about the policies and the regulations. Number 2, be sure FERPA applies. So this is kind of a given. The policies and regulations of FERPA are going to apply to all schools who receive any type of federal funding dollars from any of the programs that are administered through the Department of Education. This is going to include virtually every public school within the United States and some charter schools. Number 3, be aware of and know the rights, protections, and exceptions for FERPA. It is the job of everyone in the building, all stakeholders, to know and acknowledge all of the FERPA regulations and to comply with all FERPA regulations and policies as well. All staff members need to know what information is held in educational records and what limitations are in existence for sharing any type of that information from those educational records, and exactly who has the right to see those and view that data. Number 4, choose vendors who are compliant. This is extremely important. Only choose vendors who are going to obviously comply with FERPA and ensure that all contracts exhibit this compliance with FERPA. And just touch base with those vendors as well individually to say, hey, please remember this. Schools are liable for any non-compliant vendors, and so it's extremely important for school leaders to make sure that those contracts specifically talk about FERPA and that those vendors are very well aware of those FERPA requirements as well. Number 5, provide training for all school employees. There needs to be yearly training for all employees within a school and school district, for all stakeholders involved, to include talking about the consequences for the violations of not complying with FERPA. Number 6, implement policies and procedures that are FERPA compliant. Any type of policies or procedures that are developed within a school building by school leaders need to naturally be FERPA compliant. This is going to make it much easier for all staff to be and remain FERPA compliant in everything that they do. So, for example, shredding all old papers and documents, having a plan in place to respond to any breaches, any type of data, whether it's FERPA or not FERPA, and to make it a common practice to prohibit emails that have any type of private data or information that would be FERPA compliant. Number 7, provide encryption for emails and files. Files and emails need to have encryption to them because this provides an additional layer of protection. And that's in case any type of property that belong to teachers, school leaders, etc., anybody in the building, if that property is lost or stolen, if it has any type of private information on it, the encryption is going to help with that additional protection, layer of protection for those. Number 8, have other tools of prevention for implementation. So always make sure to have any and all types of tools in place for the entire school so that everyone involved is completely and totally FERPA compliant. Data destruction. Private information should always be handled very carefully, no matter what the situation or business. And when the information that is private has fulfilled its use, it needs to be managed accordingly, and it needs to be disposed of in a correct and legal manner. So plans that are used for data from the beginning to the end are vital and a key part of all data management programs. So a data life cycle begins with a capture, runs through organize, utilize, manage, and then in the end, destroy. And the best data destructions are clear, which is to completely clear any type of software or technology and make it clean, so to speak. Purge, this is going to be kind of like a sanitation application, and that's going to be targeted toward data recovery, feasibilities, and using a lot of the new technology and data itself in order to make this purge. And then destroy, of course, is going to be such techniques as shredding documents, etc. Surveillance is a huge key factor in FERPA policy, procedure, and regulation. As surveillance cameras are becoming more and more prevalent in schools, school leaders need to be aware and they need to be educated about all of the new technologies as well as all the evolving laws and regulations with that new technology that are going to govern the surveillance with these new cameras. Surveillance has become a major part of student safety. It is a huge part of almost all security plans by any and all schools and the leaders within those schools. But the cameras and surveillance can become a legal nightmare if they are not handled properly, if they're not handled carefully and legally, especially when privacy matters are of a huge central concern. The Fourth Amendment, in addition to surveillance and privacy, when tested in the courts have looked at surveillance and they've looked at the privacy of the students and others in accordance with the Fourth Amendment. When they look at this privacy issue with surveillance cameras, almost all courts have come to the conclusion that a plain view is going to constitute the difference between constitutional and unconstitutional searches by means of surveillance cameras. With plain view, the approach that the courts will generally use and uphold is the idea that if it is meant to be in plain view or in a regular atmosphere, it would be in plain view. They will uphold that surveillance in the school stairwells, hallways, buses, parking lots, and even sometimes the classrooms. But the use of certain telescopic lenses are still kind of iffy and up in the air because there's been a very little litigation that has been litigated or surfaced for these to be determined as to whether or not they would be constitutional or unconstitutional within the means of searches by means of surveillance cameras. It's important for schools to always notify anybody who comes through the school of the surveillance within and around the building, and that is generally done with signs, newsletters, just basic policies, and everyday business practices. If parents request to view surveillance, and this surveillance is the recording of the student for which the record is directly related to, the school has the recording maintained at the school. If all of this holds true, then it must be disclosed to the parents for whom the record is maintained. And when it's maintained by the school and it is directly related to that student, it is considered a record of that student. Additionally, it does not violate FERPA to make copies of these records for parents. However, in a lot of cases, they have to do the best that they can to try to cut those surveillance videos in such a way that other students are not within the viewing of that video. However, if the quality of the video is messed with in any way, shape, or form with the cutting of that video, then the whole video is just to be shown to the parents involved. Law enforcement is not legally privy to any of the surveillance recordings that are maintained by the school because they are student records and they are recordings that are FERPA protected, unless they were created and maintained by law enforcement, and then that makes them non-FERPA protected. In order to obtain these, there must be written consent from the student's parents to whom these recording relates directly, and the only exceptions, according to FERPA, are those exceptions of safety and health and emergencies. There are also exceptions of court orders and subpoenas, but those are the only exceptions that are listed as according to FERPA. Third-party requests for these records will often occur in accordance with open records laws from media and other third parties. And when you have to look at the open records laws and the FERPA regulations, you have to make sure that you're still legally within the confines, guidelines, and bounds of FERPA. FERPA protection makes them exempt from the open records law in most cases. FERPA allows for parents to have access to all the school records of their students, and that includes all photos, all video surveillance. These are all considered to be school records because they are directly related to the student. And of course, if it's held by the school as a record, then it is considered a FERPA privacy record of that student. Steps for school leaders to keep up with the changing privacy laws. This is really important because these laws do evolve continually. So it's important for school leaders to put together and publish policies that are going to describe the purpose of the surveillance, the cameras, and the parameters of the surveillance as well. It's important to only install those cameras for surveillance in areas that are of low expectation of privacy so that they are upheld by the courts if necessary. Make the school community aware of the surveillance and the cameras. And again, this is usually done by signage or the policies within the building and the practices, handbooks, newsletters, and any websites that advertising the information about the school. Always consult legal counsel for audio recordings. It's a very thin line with audio recordings. And whenever anybody is in doubt about anything that has to do with any type of surveillance, it's always good to consult legal representation. Be sure all protocols for retaining surveillance recordings are established and applied on a consistent basis. Consistency is going to be a huge key. When access to surveillance recordings is requested by parents, or if it's requested by the media or a third party or even law enforcement, it's important to look at the documentation put out by the Family Policy Compliance Office, and that's going to help in that determination for the photos and videos and whether or not there can be access and whether or not it's according to the open records laws or the FERPA laws. Having specific protocols in place for anything and everything by school leaders is going to make it easier to handle any type of requests for copies of surveillance videos and for the disclosure of any records under FERPA. All states, of course, have an open records law, and this gives all individuals access to all open records. Many states have defined video images to be part of that open records law. Consequently, surveillance videos from schools can also be subject to the open records requests. And some of those requests are made by media or groups of people within the community or third parties. And we have to be really careful as school leaders to make sure that the surveillance videos follow FERPA law in regard to open records law as well. And finally, we'll look at immigration and FERPA. Due to federal law, all education agencies, and that includes local and state agencies, they have to provide all children with equal access to educational opportunities. This is at the elementary level as well as the secondary levels, and it's regardless of citizenship or immigration status. Those do not matter according to federal law. This applies to all children who live within the boundaries of a district, and the immigration status of the parents or the guardians or those with whom they reside and live are not to be measured or used for any type of eligibility as well. Immigration status cannot be a question for anyone who resides within that home. Without a legally mandated reason, ICE has zero ability to request or demand any type of private information of any immigration student. And along with all of the other protected information, of course, ACT, SAT, those are testing materials, and all of the information obtained on those tests is also protected under FERPA. The allowable information that schools collect according to FERPA does not include any type of social security numbers or birth certificates. This is in order to help also protect the immigration status as well as the citizenship status of students to follow those federal regulations. In accordance with this, birth dates can be substantiated in other ways, and there are a listed number of ways in which that can be done. With all of these regulations and all things FERPA, we've shown Buff Style how to be compliant and legal, even through the change and confusion of today's technology, in order to be compliant, to constructively and legally destroy data when its use has come to an end, how to deal with surveillance as it pertains to FERPA, the immigration status and citizenship status of our students in accordance with FERPA, and FERPA as a definition and use in and of itself.